What if I told you that 3 judges, handpicked by Donald Trump himself, just looked him directly in the eyes and said no, not maybe, not partially? A complete, devastating rejection that legal scholars are already calling unprecedented in the modern era. This morning at 10 Wire, something extraordinary happened inside the marble halls of the Supreme Court. The highest judicial body in the United States dropped a bombshell ruling that constitutional experts are now describing as perhaps the most consequential decision regarding presidential immunity ever handed down in American history. This wasn't close. This wasn't divided. This was absolute. The case that brought us here, Trump versus United States, posed one fundamental question to the 9 justices. Does a former commander-in-chief possess total, absolute immunity from facing criminal charges for conduct that occurred during his time in the Oval Office? Chief Justice John Roberts delivered the court's answer in a meticulously crafted 43-page opinion. And that answer was crystal clear, leaving absolutely zero room for interpretation or ambiguity. The written opinion states directly, and I quote, "The former president does not possess absolute immunity from criminal prosecution. This immunity claim finds no foundation within the Constitution whatsoever. The indictment shall proceed forward." The final tally on the vote was stunning, 9-0. Every single justice, including the 3 conservative justices that Trump personally nominated and placed on that bench, cast their vote against his position. Have you ever witnessed a moment where someone's own chosen allies unanimously abandoned them? That's exactly what unfolded this morning. At precisely 10:17 in the morning, just 17 minutes after the court posted this historic opinion online, Trump fired back on his social media platform. His response read, quote, "The Supreme Court decision is completely wrong. I had immunity. Every single president has immunity. This is nothing but a political decision. The justices have become corrupt. I will not accept this ruling." Subscribe to this channel right now because what I'm preparing to walk you through over the next several minutes isn't merely a legal setback for one individual. This represents a unanimous Supreme Court ruling that demolishes Trump's fundamental legal defense strategy. This is 9 sitting justices, conservatives and liberals united together, delivering a clear message to Trump that he does not stand above the law. And this marks the final major roadblock to criminal prosecution being completely eliminated. Turn on your notifications immediately. Set them to receive all updates because with this immunity argument officially dead and buried, federal prosecutors now possess full authority to advance toward trial proceedings. And sources indicate that trial could potentially commence within just a matter of weeks. But here's what nobody is telling you about how we arrived at this historic moment. The timeline leading up to this Supreme Court showdown reveals that Trump has been waging this immunity battle through the courts for many months. On August 1st of 2023, federal prosecutors formally indicted Trump on serious charges connected to alleged efforts aimed at overturning the results of the 2020 presidential election. The indictment document laid out allegations including conspiracy to defraud the United States government, obstruction of an official governmental proceeding, and conspiracy against the constitutional rights of American citizens. Trump's defense attorneys responded immediately by filing a motion seeking complete dismissal of all charges. Their core argument claimed that any former president maintains absolute immunity from prosecution for any actions undertaken while serving in office. The legal reasoning they presented suggested that allowing prosecution of former presidents would create a chilling effect on the exercise of executive authority and would expose every future president to prosecutions motivated purely by political opposition. On December 1st of 2023, the presiding district court judge delivered a decisive blow by completely rejecting the immunity claim. The judge's ruling determined that the United States Constitution does not provide former presidents with any form of immunity from criminal prosecution whatsoever. Furthermore, the judge specifically found that Trump's alleged conduct, attempting to overturn a certified election, did not constitute an official presidential act deserving of any protective immunity. Trump's legal team immediately appealed this adverse ruling to the D.C. Circuit Court of Appeals. On February 6th of 2024, a panel consisting of 3 appellate judges unanimously affirmed what the district court had already decided. The appellate panel firmly held that former presidents simply do not possess immunity from prosecution and declared that Trump's claims lacked any legal merit whatsoever. Trump then escalated his appeal directly to the Supreme Court itself. On February 28th, the Supreme Court agreed to accept the case under expedited procedures given its constitutional significance. Oral arguments took place on April 25th before all 9 justices, and today, May 20th, the court finally issued its landmark decision that sent shockwaves through the legal and political world. Hit that like button right now if you truly grasp the magnitude of what just transpired. The Supreme Court of the United States, in a completely unanimous 9-0 decision, told Donald Trump definitively that he possesses no immunity whatsoever from criminal prosecution. Every single legal pathway that Trump attempted to use to avoid facing trial based on immunity claims has now been permanently closed. The algorithm determines what content breaks through to wider audiences. You personally decide whether this critical analysis reaches the people who genuinely need to see it and understand it. Because what I'm presenting before you is the highest judicial authority in this entire nation, unanimously rejecting Trump's argument that he somehow stands above the law. At 10:34 in the morning, prominent legal experts across the country began publicly reacting to this historic decision. Former acting Solicitor General Neil Katyal appeared on cable news and stated, quote, "This represents a complete and total rejection of Trump's immunity claim. A 9-0 decision means there was absolutely no division among the justices, no dissenting opinions, no ambiguity in interpretation. The court is speaking with one unified voice, and that voice is declaring unequivocally that Trump can be prosecuted exactly like any other American citizen." Harvard law professor Lawrence Tribe posted his reaction on social media, writing, quote, "The Supreme Court has powerfully affirmed a foundational principle of American democracy. No individual is above the law, not even a former president of the United States. This decision effectively removes the last major legal obstacle standing between Trump and his criminal trial." At 11:15 in the morning, special counsel Jack Smith, who leads the prosecution team handling this case, released an official statement. The statement read, quote, "We are pleased with the Supreme Court's decision today. The court has confirmed exactly what we have argued from the very beginning of these proceedings. Former presidents are not immune from criminal prosecution. We are fully prepared to proceed to trial expeditiously. We will be filing a motion with the district court requesting a trial date within 60 days. That statement represents prosecutors clearly signaling their intention to move forward with maximum speed now that the immunity issue has been definitively resolved by the highest court. At 11:47 in the morning, Trump's lead attorney, John Lauro, conducted a press conference outside the courthouse. He stated, quote, "We strongly disagree with the Supreme Court's decision today. We believe the court failed to adequately consider the chilling effect that prosecuting former presidents will inevitably have on the institution of the presidency itself. However, the court has now spoken on this matter. We will now redirect our defense focus entirely on the merits of the underlying charges. President Trump is completely innocent, and we will prove that innocence at trial." That statement from Trump's attorney represents the defense team essentially conceding that the immunity argument has reached its conclusion, and they must now pivot entirely toward a trial-focused strategy. Drop a comment right now. Tell me whether you believe this unanimous 9-0 decision was the correct call, or whether you think former presidents should possess some form of immunity from prosecution. I am personally reading every single response, because this fundamental question strikes directly at the heart of how our legal system treats powerful individuals differently or equally compared to ordinary citizens. At 12:23 in the afternoon, the White House released a carefully crafted official statement. The statement read, quote, "The Supreme Court has today reaffirmed a principle that remains central to our democratic system of government. The rule of law applies equally to everyone without exception. We respect the court's decision and maintain our commitment to the independence of the judicial process." That statement represents the current administration endorsing the decision's outcome without directly commenting on the specific details of Trump's pending criminal case. At 1:15 in the afternoon, Republican members of Congress began publicly reacting to the ruling with notably divided responses. Some members voiced support for the decision. Senator Mitt Romney stated, quote, "The court absolutely got this right. No individual, including former presidents of the United States, is above the law." However, other Republican members sharply criticized the ruling. Senator Lindsey Graham posted, quote, "This decision will haunt future presidents for generations to come. Every president who departs from office will now face the looming threat of prosecution by their political enemies. This establishes a dangerous and troubling precedent." Let me walk you through what the Supreme Court opinion actually states in detail, because understanding the legal reasoning behind this decision is critically important. Chief Justice Roberts, writing on behalf of a unanimous court, begins by stating the precise question presented before them: whether a former president possesses immunity from criminal prosecution for conduct alleged to have occurred during his presidency. The opinion then conducts a thorough review of the entire history surrounding presidential immunity claims. The court notes that in the case Nixon versus Fitzgerald, decided back in 1982, the Supreme Court held that sitting presidents enjoy absolute immunity from civil liability for official acts performed in office. But that particular case, the court strongly emphasizes, involved civil lawsuits seeking monetary damages, not criminal prosecution seeking imprisonment. And that case specifically involved sitting presidents still in office, not former presidents who have departed. The court definitively finds that the legal reasoning from the Nixon case does not extend whatsoever to criminal cases brought against former presidents. The opinion states directly, quote, "The Constitution does not explicitly grant immunity to former presidents anywhere within its text. No historical practice throughout American history supports such immunity existing, and the concerns that originally justified immunity for sitting presidents, such as the need to avoid distraction from crucial executive duties, simply do not apply once a president leaves office." The court then directly addresses Trump's central argument that prosecuting former presidents will create a chilling effect on the vigorous exercise of executive power. The court acknowledges that this concern possesses some validity, but ultimately finds it substantially outweighed by the fundamental principle that no individual is above the law. The opinion states, quote, "The potential for politically motivated prosecutions is indeed a concern worth acknowledging, but that concern must be addressed through proper prosecutorial discretion, grand jury review processes, and the constitutional requirement of proof beyond a reasonable doubt. It cannot be addressed by granting blanket immunity that would place former presidents completely beyond the reach of the criminal justice system." Share this video right now, because what I'm preparing to explain next is exactly what happens procedurally now that the immunity claim has been completely eliminated as a defense. First, the case officially returns to the district court for further proceedings. Judge Tanya Chutkan, who is presiding over this trial, will now move forward with scheduling hearings and trial preparation. Second, prosecutors will file a formal motion requesting a specific trial date. And based on Jack Smith's official statement, they want trial proceedings to commence within 60 days, which would place the trial starting date somewhere in mid-July. Third, Trump's legal team will undoubtedly file multiple motions seeking delay, arguing they require additional time to adequately prepare their defense now that the legal landscape has fundamentally changed. Fourth, the judge will issue her ruling on the trial date. Given that the immunity issue has been actively litigated for nearly an entire year, the judge may be strongly inclined to move proceedings forward quickly. Fifth, jury selection will officially begin. Sixth, the actual trial will proceed with opening statements and evidence. And seventh, a verdict will ultimately be reached by the jury. At 2:47 in the afternoon, the district court issued an official scheduling order. The order stated, quote, "In light of the Supreme Court's decision issued today, all parties are hereby ordered to appear for a status conference on May 27th at 2 p.m. to discuss trial scheduling matters. The court expects to set a firm trial date at that conference." That order represents the judge moving immediately and decisively to get this case back on track for trial. At 3:34 in the afternoon, Trump posted another message on social media, writing, quote, I will not receive a fair trial under these circumstances. The judge is completely biased against me. The prosecutors are thoroughly corrupt. The jury pool in Washington, D.C. is 95% Democrat voters. This is a completely rigged system. But I will fight back and I will ultimately win because I did absolutely nothing wrong. That post represents Trump strategically setting up a narrative framework suggesting that any potential conviction should be viewed as illegitimate. Here is exactly what we are carefully watching for over the next 2 weeks. 6 specific indicators that will reveal how quickly this case proceeds to trial. Indicator 1. What specific trial date does the prosecution formally request? If they push aggressively for July, it signals tremendous urgency. Indicator 2. What trial date does the defense team request? If they ask for 2025, it signals obvious delay tactics. Indicator 3, what does the judge ultimately decide? If she sets a date during the summer months, it means she wants this matter resolved before the November election. Indicator 4, does Trump file any additional appeals? If he appeals the scheduling order or any pretrial rulings, it could potentially delay trial proceedings. Indicator 5, do any plea negotiations occur between the parties? If prosecutors and defense attorneys meet to discuss a potential deal, it could potentially avoid a trial entirely. Indicator 6, does Trump's public rhetoric escalate further? If he directly attacks the judge or potential jurors, it could result in sanctions or expanded gag orders. Here are 3 possible scenarios for how this entire situation proceeds forward. Scenario 1, the trial happens quickly on an expedited timeline. The judge sets a trial date in July. Jury selection begins in early July. The trial itself lasts approximately 4 to 6 weeks. A verdict is reached sometime in August or September before the presidential election. This represents the expedited trial scenario where the legal case reaches resolution while Trump is actively campaigning. Scenario 2, the trial gets delayed until after the November election. Trump's legal team succeeds in pushing trial proceedings into 2025. If Trump wins the presidential election, he could potentially pardon himself or direct the Justice Department to completely drop the case. If he loses, the trial proceeds forward in 2025. This represents the delay scenario. Scenario 3, a plea deal gets negotiated and reached. Faced with a devastating unanimous Supreme Court loss and the strong likelihood of conviction at trial, Trump's legal team negotiates a plea agreement. Trump pleads guilty to reduce charges, potentially avoids prison time, but accepts some measure of accountability. This represents the resolution scenario. And while it seems highly unlikely given Trump's defiant public statements, it remains not entirely impossible. Subscribe right now, like this video, and comment with your personal prediction. Which scenario do you believe will ultimately happen? I am actively tracking all 3 possibilities. And as the May 27th status conference approaches, and as the official trial date gets set, you will see the complete analysis right here on this channel. Let me explain precisely why this 9-0 decision carries such tremendous significance. Supreme Court decisions on major constitutional questions are frequently divided along ideological lines. You commonly see 5-4 splits, 6-3 splits, extremely close votes. But when the court votes 9-0 unanimously, it sends an unmistakably clear message. It means the underlying legal question was not even remotely close. It means that justices across the entire ideological spectrum, conservative and liberal alike, all reached the identical conclusion independently. The 3 justices that Trump personally appointed to the Supreme Court, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, all voted against his position. That fact is extraordinarily significant because it means Trump cannot credibly claim this was a partisan political decision. He cannot argue that liberal justices ruled against him for purely political reasons. His own hand-picked appointees rejected his legal argument completely. That reality makes this decision substantially harder to attack and considerably harder to delegitimize in the public eye. At 4:15 in the afternoon, a prominent constitutional law scholar at Yale University, Professor Akil Reed Amar, stated during an interview, quote, This decision is as clear and unambiguous as it possibly gets. The court is saying unequivocally that former presidents can absolutely be prosecuted for crimes. This ends a debate that frankly should never have been a legitimate debate in the first place. The rule of law fundamentally requires that everyone, regardless of their position or former position, be subject to criminal accountability. At 5 in the evening, Trump held a campaign rally via video broadcast from his Mar-a-Lago residence. He spoke for approximately 37 minutes straight. He aggressively attacked the Supreme Court, the prosecutors, the judge, and the entire justice system. He claimed the decision was completely rigged against him. He claimed he would ultimately be vindicated at trial. And he claimed that this prosecution represents nothing more than an attempt to prevent him from winning the 2024 presidential election. He did not take any questions from reporters. The video simply ended. What I know for absolute certain right now is this. At 10 this morning, the Supreme Court issued a unanimous 9-0 decision rejecting Trump's claim of absolute immunity from prosecution. The decision was authored by Chief Justice Roberts. It was joined by all 9 justices without exception, including the 3 Trump appointees. The court held definitively that former presidents do not possess immunity from criminal prosecution. The case now returns to the district court for trial scheduling. Prosecutors want a trial within 60 days. The defense wants substantial delay. The judge will decide on May 27th. Trump has exhausted all legal avenues to avoid trial based on immunity claims. The trial will happen. The only remaining questions are when exactly it begins and what the ultimate verdict will be. This is the Supreme Court unanimously rejecting Trump's core legal defense strategy. This is 9 justices telling him directly that he does not stand above the law. And this is the final obstacle to trial being completely removed. The implications of this decision extend far beyond Trump's individual case. Every future president now understands clearly that leaving office does not grant immunity from prosecution. Every former president will be subject to the same criminal laws as ordinary citizens. That fundamental principle has now been firmly established by the highest court in the land, and that principle cannot be challenged or reversed without a constitutional amendment, which is virtually impossible to achieve. The 9-0 vote means this decision carries tremendous institutional weight. It is not a close call that could potentially be revisited by a different court composition in the future. It is a unanimous statement that will guide legal thinking for generations to come. Stay with this channel, turn on all notifications. On May 27th, when the judge officially sets the trial date, you will see the complete analysis right here. When the trial begins, when witnesses testify, when the verdict is finally reached, you will see comprehensive coverage here. This story is not over. This is the Supreme Court clearing the path for prosecution, and that prosecution is now moving forward without any remaining obstacles. The decision was 9-0. To